Hi guys, welcome back to my channel. So today we'll be talking about child custody and unmarried parents, what the law actually says. When I talk about the law, I'm talking about the Nigerian law. The recent conversation in the media about a celebrity child custody issue has brought a very legal issue in the surface. It is sometimes thousands of Nigerians deal with without cameras, headlines, or public statements. If a child is born, when the parents are not married, who has the legal rights to the child? That's what we are going to look at today. The most important rule, the child comes first. That is the most important rule. Now, the starting point is the Child Rights Act 2003. The most important legislation on child custody in Nigeria is the Child Rights Act. What does the Child Rights Act provide? Section 1 of the Child Rights Act 2003 provides that in every action concerning a child, the best interest of the child shall be the primary consideration. That single sentence is asking practical questions. So, what arrangements will produce the most stable and healthy life for the child? Although the Child Rights Act is a federal law, child custody is technically governed at the state level. So, each state must pass its own child rights law for the provisions to fully apply within that state. Today, all 36 states of the Federation have enacted their own child rights law with varying levels of amendments, which means the best interest of the child principle is recognized across Nigeria. This principle has also been interpreted by the Supreme Court in William and Williams, where the court explained that the welfare of the child includes the child's emotional well-being, the child's education, physical care, moral upbringing, and overall development. The focus is not on the rights of the parents as individuals, but on the total life of the child. Let's look at child custody outside wedlock. When a child is given birth to and both parents are not legally married, who has custody of the child? What happens to the child? So, under common law legal principles, a child born outside marriage is automatically in the custody of the mother at birth. However, the Child Rights Act has moved the law forward significantly. Sections 68 and 69 make it clear that either parent can apply to court for custody, access, or parental responsibility. The court is empowered to grant custody to the father, the mother, both parents jointly, or even another suitable person if that would better save the child's welfare. The parents who want custody must file an action in the appropriate court, usually the family court division of the state high court of the state where the child resides. In that action, the parent can ask for custody, access, maintenance, and so on and so forth. The most important part of the case is the ability to show that the proposed arrangement will benefit the child. The court will look at the child's current living situation, the stability of each parent's home, the time each parent has spent caring for the child's schooling and daily routines, and the mental, emotional, moral fitness of each parent. The court will not grant custody to a parent who is mentally unstable. The court can also make temporary decisions about where the child should stay while the case is ongoing. At the end of the process, the court may grant sole custody, joint custody, or custody to one parent with defined access rights for the other. So let's look at the direction Nigerian law has taken. Modern Nigerian law no longer focuses on whether a child was born inside or outside marriage. The Child Rights Act makes it clear that every child has equal rights and deserves equal protection. The question the court asks is always the same: which arrangement will give this child the most suitable, secure, and good life? It must be noted that custody is not a tool for settling relationship disputes. It is a structured legal process designed to protect a child's future. There is a clear path, there is a clear standard, and there is a system for enforcing it. You do not need to rely on guesswork, family pressure, or public opinion. The law already provides a framework to follow in child custody. Let's draw our attention to Section 3 of the Child Rights Act, which provides that in every judicial or administrative proceeding affecting a child, the child who is capable of forming his or her own views shall be given an opportunity to express those views, and such views shall be taken into consideration having regard to the age and maturity of the child. So this means that in custody proceedings, the child is not merely the subject of the dispute. The child can be a participant in the decision-making process. Now, I want to ask, is this a good law or a bad law? I'll be needing your opinion in the comment section. What do you think about this law that in every judicial or administrative proceeding affecting a child, the child who is capable of forming his or her opinion or views shall be given opportunity to air those or express those views, and such views shall be taken into consideration having regard to the age and maturity of the child. Is this law a good law? What do you think? Let's engage in the comment section. Let's know your views. Let's know your opinions. Thank you. See you in my next video. Bye.